Okay, I will submit you. There is a juridical cases, so applying of legal norms. I think that it will be. I understand that sometimes it may be difficult because language is English and the decision. So legislation is Ukrainian, so it may make some hinders, but I think that it will be quite nice. And brief thesis. Do you understand what does mean thesis?
Somehow, yes.
Did you have maybe someone had such practice? It's like writing some little scientific works for about 3-4 pages, but there should be your own positions, no plagiarism. First, you'll have to investigate chosen topic, read at least 5 scientific articles at the topic, and then write the work. But you'll have to propose some your own decision for some troubling questions in the legislation. For example, it may be legal regulation and protection of intellectual property right in internet. It's a very troubling question. Or maybe something about some kinds of activity of entrepreneurial activity of banks, and doesn't matter. It can be any question that there is some troubles in the legislation and practice of applying of this legislation in Ukraine, or maybe it is maybe some comparison in Ukrainian legislation and with foreign legislation. It also will be quite nice. Okay, so such 3 kinds of our possible work, but even in this case, I'm afraid that it will be hard for me somehow to estimate you and about marks and points at our examination at the end of the course, because I have 97 groups and 300 students. For this course, I have 3 floors, and as I see that at workshops, not much people want to answer the questions and to work and to say something at all. So it will be difficult for this system of university to accumulate needed amount of points. That's why maybe I will make some test for you at the end of the course. And the result will be a result of the examination of the test. But once you'll be not agree, then we make discuss, and it may be verbal answers additional. Okay, is there any other questions?
Okay, thank you. And another one, do we need to attend our workshop every week, or is it needed for our marks or something like that?
Yes, I think that workshops is a must. It's compulsory. Lectures, I will send you video lectures, and at the workshop we will discuss all troubling questions that could arise at the lecture, and also I will prepare my own positions which I want somehow to highlight you at the workshop. So I think that such work will be appropriate for us.
Okay, thank you, I understand.
Maybe if there is no other organizational questions, maybe we will come to our topic and to entrepreneurial or business law. Maybe you had some questions during the lecture. I asked you to note questions. Once you have no questions, then
Sorry, I have one question.
Okay.
Still, please, we have 2 pairs of our lectures, like in timetable, or we have be only at 10:30 like today?
I didn't understand quite enough your question. You asked about the first pair, the lecture, and about second pair, the workshop, or there is a third pair, or either.
Yes. Do we need be at both lectures, like first and second, or only at second, like today?
I written everything the letter that I submit you video lecture every week or week after week because we have just once for 2 weeks a lecture. I submit you video lecture. I have plenty of groups and it's very much more. It's more practicable for you to watch this video at the time when it is appropriate. Also, the sound is very weak because I have 3 flows, and for one flow, 100 person. It's a maximum for Zoom. So I decided that this video lecture was also with very bad sound. I don't know why, but I had no time to re-record it. I hope that next time the sound will be much better. But at the workshop, we will discuss all questions, main questions. That some positions which may collide in the legislation, which may be difficult in perception. We will discuss everything this at the workshop. So our work will be in such case.
So we need attend only workshops, and before this we have to
Look through
prepare
the
like
lecture,
watching
surely.
lectures. Thanks.
Okay.
Excuse me, will we have some submissions, for example, some works in the classroom, or do we need only workshops to attend?
Attend workshops and decision of juridical cases. I will submit you them later. It's just first workshops. In any case, it will be difficult for you. As I see the other groups, it's difficult in perception of the material, even in Ukrainian. It's hard material for, especially for students who are not lawyers. That's why I think that I don't want to heap you of too much work, and also I have no enough time to check all these written works. So for now, such version of our collaboration, I think it will be quite appropriate.
Sorry,
I will-
and the last
yes.
question, what is the rating system? How many points we can get for our answers on workshops, and how many points we can get for our works?
Okay, everything is written in the syllabus, but 5 points is for verbal answers at the workshop, and also for the juridical case, it may be from 5 till 10 points, and for thesis, it may be 10, 15, and even 20 points. It will depend on the quality of the work, and in some cases these works may be even published once they will be really of high quality, but it happens very rarely. In my practice, it was about maybe 5 times that thesis works were quite appropriate for the publication. And then the scores will be much higher, and even it will be the maximum points for the examination once your thesis will be published. I will decide for the publication, but it's exceptional cases. Oh, very high.
Thank you.
In any case, I paid your attention that it's very hard for such amount of students and troubles with language because legislation is in Ukrainian. In any case, and it's not your mother tongue. In any case, it makes some obstacles, and that's why it's hard for you and for me to estimate you and you to accumulate needed scores, even minimum 60. It's really hard at the workshops. That's why I think that I will make some tests for you for all material. So you'll have to study the material in any case. And such variants will decide this trouble at the end of the examination. Okay, is there any other questions? If none, then I think that listen, I will ask you questions. I want to understand how you manage with perception of the material, but we will discuss it. Don't be afraid to answer. Once you don't give the correct answer, I won't apply any penalties, just additional points. And in any case, I will answer myself at the end for this question. First, very simple. Which forms of ownership in Ukraine do you know? Ownership in Ukraine, it's provided by constitution and other norms.
Private ownership and maybe some kind of public or state ownership, and also
State
public
ownership, yes. Public and state, in this case, it may be the same, but public, we may say about
for example.
municipal, yes?
Yeah.
State and municipal, that's different forms of ownership in Ukraine, but together we may in general say that this is public ownership. Okay, and also private of physical persons and private ownership of entities. We may differentiate it, and it's very important because very often especially about real estate, it's more practicable to register some real estate, doesn't mean land plots or some offices for physical persons, not entities, because juridical liability for entities about the agreements, under the agreements and taxes, maybe then that this property, real estate will be sell and will have to sell them, and it will be confiscated, like in the, liability. These kinds of ownership differentiates greatly: private of physical persons and private ownership of entities. Who can be an entrepreneurial? Who can be registered and work as entrepreneurial?
Every person who is legible for its own first of all, the people who are older than 18 years old,
Yeah.
and also they should be responsible for their activities.
18, even we may say that 16 years it is possible to register a person as entrepreneurial once there is a court decision or allowance of one of from parents. Yes, that's general provisions, but also there is some bans for entrepreneurial activity, which is connected with state offices. So once you are state officer or notary or judge, you can't be an entrepreneurial. I think that you may understand why this is so, because they may abuse with their state power. Yes, and notary, they may be not state, they may be private, but they also have an access to state registration system of property, of real estate, etc. So it is also for not abusing abuse of their authorities, which maybe other bans. Court may revoke legal capacity of physical person, but that's just in criminal process, abuse of power, masonry crimes, for maximum period of 5 years. Corruption, such crimes, but when there was a court's decision, not just persecution. But the maximum period of minimizing of legal capacity is 5 years. Okay. Another question. Okay, do you understand what I am saying about? Or maybe there is any question about our discussion? Can you hear me?
Yes.
Yes.
Okay. Which subjects we have very specific situation that except for legal entities and physical person entrepreneurs who are surely taxpayers in any case once they are entrepreneurs, there may be a subject of like taxpayer without the status of the entity. Agreement. So separate agreement is registered as a taxpayer. It is there is two variants: a property management agreement. It's more from the Anglo-Saxon system of law, duplicating of ownership between someone who will operate, make management, especially it may be banks who are operating with packages of securities, and another person who owns and will have some remuneration. And it's also a simple partnership agreement. It is enshrined in the Civil Code. Also, this person may act together under the agreement without creation of legal entity, but they should pay taxes for under the results of this activity. Okay, it's quite a difficult question for perception, just for you to have some understanding. And about difference between commercial agreements and civil agreements. How do you understand the difference between commercial agreements and civil agreements? No vision about it. We have commercial code of Ukraine and we have civil code of Ukraine. There was also, it was also in the lecture and video lecture that in Ukraine we have a double regulation of private attitudes because the process of creation of entities and different agreements are regulated in the civil code and in commercial code also. So sometimes there is a duplication and sometimes collisions. And once there is a collision, it's hard to decide which provision will be preferable for these attitudes. And that's a negative version. But mainly civil code we will apply as a subsidiary. Once it is not regulated in commercial code, we will look to the SULE code. About difference between commercial agreements and SULE agreements, it depends on how many times it is possible to sell own production, give services without creating an entity or registered person as an entrepreneur. Mainly, our tax authorities think, because it is not enshrined strictly in the legislation, they think that 4 times a year, except for municipal fairs, is possible. The rest, you have to register an entrepreneur. So system activity means commercial activity and commercial agreements. But surely that you may sell your flat, your real estate, your own property to somebody, and it will be SULE agreement. Also, for some professions like authors, lawyers, they may work without creating an entrepreneurial registration, but in any case, they register their professional activity. And after the year is passed, they have to submit declaration, and after a few months later, pay personal income tax, like physical person. So in any case, taxation will be. Maybe there is some questions from your side about this problematic. Everything is understandable for you. Do you understand me?
Yes, it's clear.
Everything is clear. Okay, that's nice. But mainly when everything is clear, that means that not everything is clear. Okay. What is the main goal of chambers of commerce? I will change the slide. Chambers of commerce. What is the main goal of chambers of commerce and industry functioning? It is written main provisions about certification. Surely that it's very important, and in some cases it is impossible to, for example, to import some goods without certification in Ukraine. So it may be certificated in some other country, but once it's not certificated in Ukraine, and we didn't sign an agreement with that country for applying their certification system, then we have to do it in Ukraine, and it for now chambers of commerce and industry help us in this. So they have such such authorities, and also they may issue conclusions of force majeure. What does mean force majeure? Who knows?
Some unexpected situation.
Yes, unexpected, but of what kind unexpected situations may be? Because it's not enshrined in the legislation strictly what may be force majeure and what not. So sometimes it may be ad hoc. Decide court may decide it every case separately, but there are some provisions that always will be force majeure.
For example, some natural disasters
Yes.
like earthquakes, storms, etc. Also, the quarantine,
Yes.
which was unexpected, and for example, the unexpected death of the relatives, like of the wife, for example.
Sometimes maybe, but for example, for economic commercial agreements, it won't pay any attention for this, whether your relatives died or not. But about natural and technical catastrophe, for sure, hurricane, flood, fire, it's and once it made an obstacle for, and COVID surely also quarantine. Lockdown especially. So it made an obstacle to you to fulfill your agreement. And that's absolutely force majeure, and in any case, it will delay fulfillment of agreement, but it doesn't. In many cases, it doesn't matter that you won't fulfill your agreement. It doesn't annul your liability, but sometimes once production is spoiled, is destroyed, so it may be applicable. Also, it may be sometimes a robbery, and even sometimes it may be staying at the customs, when you're importing and exporting trades and goods for a long time, and storage of the products have finished, rotten, spoiled products, etc. But in this case, court not always accept this as a force majeure, because they think that customs authority won't apply such staying for so long a time once you prepared all documents and everything is fine. So it's your blame, it's your guilty. But it may vary. Also, under the Chambers of Commerce and Industry, there are functioning international commercial arbitration court, and especially when we have international elements in Ukrainian agreements. So there may be provided in the agreement that sides will apply to this international commercial arbitration court. And even it may be that one side have his own judge, another, and one will be from the International Commercial Arbitration Court. So they may choose their judge, and the third will be from the International Commercial Arbitration Court, that will be signed by administration of the court. It's a situation of commercial attitudes. So these cases may be decided and heard in like not state court. Yes, it's a commercial court, not state. But the decisions of this court will be provided but by our executive state system. Also, for now, we have not only state executive authority, but also maybe private companies and physical persons who have license to fulfill court's decisions. Okay, do you have any questions?
No.
Discussion is very poor today. Somehow it would be nice that you to try to discuss somehow lead the conversation together with me, and also I will give you additional points for everybody who will talk at least. Now you understand how it is difficult at the workshops to estimate you, to give you some points, because you even don't want to speak at all. Not saying about some questions from my side to you. It's even difficult for you to ask something sometimes. And that makes real troubles for estimation. And that's why workshops in this course is second lecture.
Because we are the mathematicians and really introverts. Yeah.
And if you start speaking all, that's going to be very noisy.
If I didn't hear your notice. If
we all, if we all speak, we're going to make very noise.
No, surely that everyone should speak not together, but for definite period of time, one speaker than the other. But the essence of a workshop is in collaboration, so you should make some efforts for it. You've chosen this subject. Doesn't matter whether you are mathematics or physics or whatever who you are. What is the difference between the public joint stock company and private joint stock company? Who may answer me this question? Where is it?
When it is the public stock company, I think that we can buy these stocks not being the part of the organization.
Yeah, you're right. Your surname, please.
Kavara.
Repeat, please.
Kavara.
Kavara, because not to be a mistake. Okay, thank you. Yes, public joint stock company may offer off its shares at the stock exchange. There are more than 100 shareholders must be in public joint stock companies, but private, there is a preemptive right for the period of 30 days for other shareholders to buy your shares. And after that, it is a possibility to sell them to somebody else. So that's the main difference, but surely that's there are plenty other little differences. What does mean state monopoly? Do you know some kinds of state monopoly? And also they may be a natural monopoly, they differentiate. But it's also a kind of ban. Their spheres when it is impossible to have entrepreneurial activity for private companies. It may be just a state monopoly. Do we have yet in Ukraine a state monopoly?
Yes, of course, it is Укрзалізниця, and it is the only provider of transportation on railways in our country. Yeah, and also it is, for example,
nuclear energy.
Yes.
Still, it is a state monopoly, and hard weapon. And Укрзалізниця, they want to sell it, to privatize. For now, it's still yes in state, but about nuclear energy and hard weapon, still it is in state monopoly. But maybe I even can't mention which are the spheres. There no such spheres, it seems to me. About natural monopoly, it's more practicable to have one or few entities in the sphere, like gas and oil transportation. The same pipes are owned by one entity, but in my opinion, it should be always in the state monopoly, because these cases with prices for this transportation, it should be regulated more with help of states, because once there is no competition, price is very high. What is, yes, is there any question? What is the main goal? We will have to reconnect, you know, because it's not licensed. Zoom. What is the with the same link? You will reconnect with the same link. What is the main goal for creation of industrial and financial group?
To have financial profit.
Yes, to have for profit. That's right, but I want to find the here we have no yes, financial and industrial group. That's very special groups because they have no status of entity, of legal entity. Such organization, and they may be created only under the decision of government, of Ukrainian government, for some period of time for fulfilling some state programs, for example, or at some spheres to make it more prospering, a very important sphere for the state. And the main goal exactly for creation, it's, in my opinion, the absence of value-added tax on goods and services which are circulated within the trade and industrial group. That's really very important. But for now, it is even not regulated with help of law, because that law that was previously was revoked in 29 on the industrial and financial groups, and they do exist in practice, in reality, in Ukraine, but they are not regulated. So there may be decision of government, but that's very bad that there is no separate law or even provisions in commercial code which would regulate this situation. And that's a very negative moment. We have other situations where it's not regulated. For example, even President of Ukraine, just a constitution, a few words. It's his activity is not regulated under the separate law, and many other situations when we have no regulation. But it doesn't mean that we have no such attitudes in practice. But speaking about industrial and financial groups, there is such a position that in constitution that for private companies and private physical persons, for physical persons, that they may do everything that is not forbidden by the legislation. It's in contrast with state offices and state authorities. That's why it's not forbidden and it's functioning. Okay. Do you understand the activities of these groups and what does it mean? Yes? Everything is clear?
Yes.
Hope so. Do you know how can I note who is present? Is it possible to make a screenshot or somehow otherwise in the Zoom? I don't know.
Yeah, you have a list of participants.
Yes, I know.
Yeah, so you can make the screenshot, yes.
But how can I make it? But I can't do it somehow, some way. Wow. Can do you have possibility to do it by yourself, or it's just organizer of conference may do it?
Yes,
Everybody can.
Okay, I would ask you to do it somehow, some way I can do it.